Hi guys, it's Kathy. I hope you're doing well. I hope you got plenty of rest from a couple hours ago. That was fun. Last night's live stream was fun. Thank you again, Long Talk with Mike, for rating us. That was really cool. I did play the clip that I was going to play for today's live stream during my live stream last night. That's why if you saw the thumbnail and the title and everything just a couple hours ago, I had to change it. It was wrong, so I accidentally used that last night. That's okay. I got more content. It's not a big deal. We're going to start off nice and slow in Colorado. Again, I don't know what's... I did press play. Of course it's not playing, just like last night. It's alright. I'm gonna win. Last night, I also lost power for a second. After this clip didn't play, well, the clip lost power. There we go. Hope that doesn't happen today. It sucked. Yeah, it stopped playing. Just stopped playing. It just gave up. I did say we were starting off slow. Oh my gosh, it stopped again. Okay. We'll come back to this one later. It's not playing. I don't know why. Jacobs will play.
Mr. Is he just FDA? Judge.
If you're not familiar with Judge Jacobs, he's really good. And I think you can only see him here, guys. He's from Indiana. He doesn't mess around. You don't mess with him. You just don't.
He has a warrant in here. I think he requested withdrawal. He's had a lot of health issues. I suspect I can probably get some medical records from him that may persuade the court to withdraw that warrant, but I have not seen him today. He does have a warrant in for violation as well.
Well, we'll issue the FTA today, although he already had one from October. How do we get this one set on? Do we think we were going to turn him in and get everything resolved today?
Yeah, I think that was probably the plan.
Okay.
So we would object. We would move to continue and object as it was.
All right. We'll show an FTA over your objection. That warrant remains. And if you can get a turn-in date, we'll do that.
Thank you, Judge.
You're very welcome. All right. Now I've got people who have identified themselves. Oh, we lost. No, we have Michelle. Amber Davis, 10C02-2207F6927. And Ms. Davis, Christy Lemumin is your attorney. Christy Navely is here to cover for her. You have any problems with that? Oh, never mind. Ms. Lemumin's here also.
I'm going to go finish myself. Amber Davis.
All right. So what are we thinking today, Christy?
Is Miss Davis on Zoom?
She is. She doesn't have her camera on.
When Your Honor had passed out for her to do a... Sorry, I'm trying to pull up my notes of...
Ms. Davis, can you get yourself unmuted so we can talk about this? There we go.
Actually, I don't believe Miss Davis and I've had a chance to speak yet.
Failed to report for a scheduled probation appointment to transfer to Kentucky, so that means Shelley's got this and we don't have much of a recommendation. So let me double check, but yeah. Ms. McCray, if Ms. Davis were to admit, does the state have a recommendation?
Judge, it looks like this is one of these absconding for about 8 months now, so I'm going to be requesting a revocation.
Let's see. Thank you, ma'am. Warrant was issued in May. Served, 6 months.
Ms. Davis, have you had a chance to get the paperwork done to transfer this to Kentucky?
Told Shelly, she told me that we had to wait till court to be able to even discuss it, to see what they were going to place me back on probation or what they were going to do.
That makes sense.
Do you have, because I believe there's a fee to transfer. Do you have the fee right now to get this transferred?
Yes, ma'am.
Your Honor, I would give her a chance to go get this transferred over to Kentucky, and then maybe come back to make sure that that is completed.
Judge, we can't transfer her probation while she's in revocation status. It can't be done.
How close can we get, Shelley, before, like, can she come and get all the paperwork and she can't leave? You can't accept money with, like.
I gave her the information that she would need to bring back to transfer it, but we can't start anything while she's still in revocation. We can't get anything submitted.
So, Ms. Davis, do you have, Shelley gave you information that you had to get together. Do you have everything together that if we finish this today, you could be in Ms. Stockdale's office by the end of the day, pay that fee and transfer your probation to Kentucky?
The only thing I would not have today is the money because I don't get paid until Friday.
Okay, so if I set this out for 2 weeks, you'd be able to do that then?
Yes.
All right. So what I'm looking at, Ms. Davis, is when we started this case in July of 22, you had a lot going on. You had 3 pending cases and some probation cases fighting with. To me, that's screaming instability more than anything else. I'm inclined to put you back on probation if you believe you can successfully transfer to Kentucky. If you can't, though, then we're wasting our time. We just file another petition in the future, and I'm going to revoke the whole thing because you told me you could do something, you really couldn't do it. Are you fairly confident that when we come back in a couple of weeks, you'll have the money's not, I'm not concerned about that when we transfer you, you're going to be successful in Kentucky?
Yes, sir.
All right. So you think in 2 weeks you'll have that money?
How much is it exactly? Because my check's only $185 this week because my mother-in-law has been in the hospital, so I'm short on the money this week, and I only get paid every 2 weeks.
So that if we go to February 24th, you think you can squirrel it away by then?
Yes, sir, for sure.
Okay. Yeah, this whole criminal history just says instability. I'm not sure I want to lock her up for that indefinitely, but at the same time. Okay, so Ms. Davis, here's what we're looking at. If we're going to set this for February the 24th. If on February the 24th, you come here in person that day, you have the whatever money you need from Shelley to transfer to Kentucky, you have whatever documentation she might need. If you admit, I'll return you to probation, send you over to her office that same time. You can do all that stuff and transfer your probation to Kentucky. You've got to be here in person that day as a good faith gesture to show me that you're responsible enough to follow through. And if you do, I'm going to put a note in here. If you do that, then that's step one, and I'll follow through with my end and send you back to probation in Kentucky. You don't, then I'm not going to trust you to be stable enough at this point. And then we've got to talk about how much time you would have to serve if you were revoked.
Okay.
So in person, February the 24th, with everything you need to transfer.
Yes, sir.
All right. That is it for today. Then show your whatever. I'm not sure we need to show anything on the state's objection. Go ahead. You're good.
Just a quick clip from
Thank
him
you, Your Honor.
because
You're welcome.
he hasn't streamed in a while.
Terms and slurs to the individuals involved.
Oh, look.
However, Miss Willis, it is well documented. She was
It kept playing. It's not supposed to play when we're not watching it. The clip that wouldn't play just kept playing. So what? I'm not going to start it over. I'm going to start it at like here.
levels on behalf of Miss Willis, who appears in person to my left.
I'll be right back.
I have notes that said that the defendant is going to plead guilty to an added count 2 of attempted assault in the 3rd degree, class 2 misdemeanor, that count 1 will be dismissed. Is that everybody's understanding of the plea agreement?
Yes, Your Honor.
Ms. Willis, I'm going to ask you some questions now, so I'll have you be closer to the microphone. Is that your understanding of the plea agreement?
Yes, sir.
Have you had enough time to speak with your attorney?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
This form goes over the details of what it means to plead guilty and what rights you have, as well as what rights you're waiving if you do plead guilty. It appears to have your signature on the back. Did you read through and go through this form?
Yes, sir.
Did you do so with your attorney?
Yes, sir.
Any questions?
No, sir.
The charge of third-degree assault means that you knowingly or recklessly cause bodily injury to another person. It is a class 1 misdemeanor normally, but the DA has agreed to plead it to an attempt. An attempt means that you took a significant step towards the commission of the crime of assault in the third degree. Do you understand the elements of that crime?
Yes, sir.
Possible penalties for a class 2 misdemeanor carries up to 120 days in jail, up to a $750 fine, and or both. It could also impact any probation, parole, or immigration if those apply to you. Do you understand those possible penalties?
Yes, sir.
Are you thinking clearly here today?
Yes, sir.
Are you under the influence of anything, alcohol, drugs, medication?
No, sir.
Has anybody made any threats or promises to get you to plead guilty?
No, sir.
Is there a factual basis, Ms. Villalobos?
Would be waiving one, Your Honor.
Ms. Willis, to the crime of attempted assault in the third degree, how do you plead?
Guilty.
Court will accept your plea, find a knowing, voluntary, intelligent waiver of your rights after advice from competent counsel. There is a waiver of a factual basis. It looks like everybody's all right with going forward to immediate sentence. So, Ms. Williams, can you tell me what the people's position is, as well as any victim input?
Thank you, Your Honor. The people are not objecting to a probationary sentence of 1 year with conditions to include standard statutory conditions, as well as anger management classes, community service in the amount of about 24 hours, and monitored sobriety. Your Honor, this case came about when Miss Willis was with some, I don't know exactly what their relationship was, but I'll call them friends or acquaintances, up in the area of the casinos. They encountered two individuals, the victims in this case, and Miss Willis's friends began using slang words indicating information, gang ties, essentially, and accusing the other individuals of being affiliated with gangs. I don't know exactly whether Miss Willis was one that was accusing the other parties of being associated with a gang, but I do know that her friends or acquaintances were. Things escalated into a verbal altercation, and Miss Willis punched the victim in the mouth, causing lacerations to the inside of her lips. Things continued to escalate. The victims tried to remove themselves from the situation, and eventually parties separated. This is concerning to the people given the unprovoked nature of the offense here. The victims really, in my review of all of the evidence in this case, the victims didn't appear to really initiate anything or escalate the situation. They were attempting to leave. The named victim did record some of the altercation with her cell phone. One of my major concerns, Your Honor, is that Ms. Willis was on an active deferred judgment for reckless endangerment out of El Paso County when this case happened, and that's case 24M6065. That's concerning to the people given that she was on probation at the time of this offense and still engaged in this type of behavior. She doesn't have much in terms of criminal history aside from that. I see a disorderly conduct in 2018 and a deferred judgment to a hit and run traffic offense in 2024. The big concern for the people, Your Honor, is the unprovoked nature of this attack while she was being supervised on a deferred judgment. The people have considered the mitigation that defense counsel has provided, and I'll let them get into that more. But that was a factor in the people's decisions here. Ultimately, though, the people would not object to 1 year of probation with anger management, 24 hours of community service, monitored sobriety, and all other standard terms of probation. The named victim here, we are VRA compliant. The named victim was very upset about what happened, but hasn't been very involved in the case proceedings other than that.
Do you have any information, and maybe Ms. Villalobos knows more, regarding what's happening in the El Paso County case?
I do not know, Your Honor.
Your Honor, they are trailing this case. At this time, her deferred was set to end a few months back, so they're just trailing to see what happens here.
All right, thank you. For the defendant,
Your Honor, I would just like to begin by stating that I do feel there are some misrepresentations made as to the facts of this case. Ms. Willis was there with family members that were actively engaging, as Ms. Williams said, in yelling gang terms and slurs to the individuals involved. However, Ms. Willis, it is well documented, she was not involved in yelling any gang slurs. She's never been a part of a gang. And in fact, she was the only person in this group of individuals who was actively trying to get everybody out of the situation. She even went so far as to pick up a grown man and carry him away as trying to remove them from the situation. And in addition to that, the male victim associated with the case was in fact yelling gang slurs back at the individuals when Ms. Willis was just trying to get everybody to leave the situation. Ms. Willis did get into a scuffle with the named female victim over a phone that she was recording. Ms. Willis did get upset that the female victim was recording instead of trying to assist in separating everybody. And Ms. Willis understands that she shouldn't have done that. She understands she should have walked away. But in the moment, she just thought about trying to break everybody apart. And that is why she's pleading guilty here today, is because she knows she should have just left the situation. And in addition to that, we would be asking the court to accept the proposed disposition and sentence Ms. Willis to probation, because in light of her El Paso case, she did exceedingly well over there on probation. And she's only getting revoked because of this case and because she's choosing to take responsibility here and plead guilty. And we do believe that she can be successful again on probation. And as Ms. Williams stated, she does have a limited criminal history of just the one El Paso case and nothing further in addition to that. Ms. Willis would also like the court to know that she is pregnant right now. She does have a high-risk pregnancy. Her son has a heart defect that does require a maternal fetal specialist and frequent appointments. She also has frequent doctor's appointments as she has placenta prevera, which is a medical condition with pregnancy that requires C-section for delivery and also increases the risk of preterm birth or stillbirth. She is due in May at this time, but they are going to take her son early via C-section to reduce any risk or complications. And in addition to that, we would be asking that Ms. Willis be able to transfer her probation down to where she is currently residing, which is not in the Jefferson County area. I don't want to state the exact location of where she's residing, as Ms. Willis is the victim of an attempted murder case that is pending right now, and her location is currently being hidden for that reason. Thank you, Your Honor.
thank you. Ms. Willis, you do have the right to speak to me before I impose sentence. Is there anything you wish to say?
I do.
If you want to say something short.
No, I'm okay.
All right. Obviously, things got out of hand here, and we wouldn't be in this situation. We wouldn't have this plea unless there's something that went above and beyond. I'm not making any statements about anybody else's involvement. There's a warrant, at least for the arrest of one other person in this case that I can tell. So I'm not going to presuppose anything else that might have happened or what anybody else might have done. But obviously you're here and you're pleading guilty for a reason. There is that deferred judgment out of El Paso County, and they filed a motion to revoke. I have no idea how they're going to handle that case. But you also face those potential consequences. So I do think that the entry on your record of at least one conviction and potentially two convictions is a significant sanction for what happened. I am going to place you on 1 year of probation. I'll have the statutory terms and conditions. I am going to order monitored sobriety, a substance abuse evaluation and treatment, anger management. I'm not going to order the requested community service at this time. I want you to take care of everything else you've got going on. But recognize if you fail on this one, there's that 120 days jail sitting out there. There's the possibility of community service, a bunch of other stuff that can
Your Honor.
happen.
My apologies. If I could just make a quick record as to the monitor sobriety, I forgot to touch on that. We would be asking the court to make monitor sobriety optional and up to probation at this time. It was not a complaint or noted by the police officers that Ms. Willis was under any sort of substances or alcohol at the time of these events. So we would ask that that be optional.
All right. I don't know if I said it, but I will place it at the discretion of probation. A lot of that will have to do with the substance abuse evaluation and treatment, if they think that's a significant concern towards the commission of any new offense. So I am going to leave that to their discretion. I'm just looking at the other case really briefly. I'm also going to authorize the transfer of probation. That will be up to probation. One of the things they look at is that you check in and that you be in compliance of this probation, but that'll be their decision in this case. There will also be the court costs. I'm not going to suspend any specific jail because I don't know if there's a violation, what will be the possible repercussions, but understand all of that 120 days is available to me. I'm also not going to issue any fine beyond the normal court costs. So that'll be the sentence of the court. I'll have you go over to the clerk's office. I'll have you sign off on the paperwork, give you the information about it. Anything else we need to address?
Nothing further, Your Honor. Thank you.
All right. Thank you, Ms. Willis. Good luck to you.
Thank you so much.
You forgot the word adult, Bren. You forgot to put the word adult in there. Okay. Let's see if the next one plays. I don't even know if it's going to play now. I'm so nervous. It is in fact not playing. Come on, it's Judge Hammond. We need a little Judge Hammond. It's just 7 minutes long. All right, I'm going to bump it up 30 seconds. Maybe that'll help. No. I don't know. I have an idea. Okay, that works. I don't know how. I don't know why, but I love Judge Hammond.
Well, let's see. Who's the next?
Number 11.
The king and the queen. Come on up. Oh, do you want to wipe?
It's okay.
You can move over.
That's all right.
Did this one if you want.
Well, then just rub your arm all over that for the next person. Give me just a second.
This stream is brought to you by Monica. Monica, thank you for buying my coffee this morning. It's called Chocolate Bliss. Thank you.
Okay, so this is on for a judgment. It says that for Naomi and Noelle, you were married and living together at the time of conception and birth for both of those children, yes? Not for Nolan. Conceived before. All right, and you acknowledge that you're the father of all three, yes? Okay. All right, so the answer as to that, parentage, and this is all just legal mumbo jumbo. $75.40, the family code says that if a child is conceived and born during the course of a marriage, if you're married and living together, that there's a conclusive presumption of parentage. So I will join the mother as the other parent to this case and to the judgment and find the calculation.
So, Your Honor, the calculation is based on dad's income from 2025 combined with his unemployment towards the end of the year. Mom has expressed some issue with dad being on unemployment or being unemployed. And then mom's income is based on her tax returns from 2025.
Brent, if I ask JK the same
Okay.
question, is that offensive?
Yeah, so
Would I offend JK? Okay, I'm going to ask JK. If it's offensive, then I'll apologize later. If it's not offensive, then I won't. Are you a bogan, JK?
what she's saying is that because he didn't close the bank account, she got records that showed how much money he was depositing into the account.
Yeah.
Is that right? Silly boy. Yeah.
Guys, I'm not here to argue, judge whatever you want.
Oh, it's not what I want. I mean, what I want is information that allows me to make an appropriate order. According to this, you have 3 children together. It says, oh my God, how is that even possible? Okay,
Can
so 3
Kiwis
minor
be
children.
bogans, or are they just not?
Although one is turning 18, Nolan is turning 18 in July. And is he graduating from high school this year? Okay, so that child will be dropping off for support purposes at the end of July. So this says that the children are spending, it says 1/3%. Oh my God.
It's 1% with one of the children and then 0 with the other 2.
Who's the 1% with? Is that Noel? No, wait, with his father? So the paternal grandfather.
That's he. He is an elder in our church. We'll bring Noelle maybe once a month. So she does get to see her dad for at least during church service and after.
That accurate?
I've only seen my kids twice since Christmas, and one was the
Can you turn the microphone on? Just hit the base of that.
It's
No, the base.
And there's a button.
And I actually don't need you to put it right there in front of your face.
Oh,
That's too much. Okay.
just like that. Okay. I'm not here to dispute the 1% or I just, the problem is that me and Jennifer, we have we're going through a divorce and I want to go forward with that divorce. Custody and everything is going to be decided. I was up at the law office here and they said all I need to do is turn in my financials basically, and then we can go forward with the mediation. We haven't been able to go into mediation because our
No, Judge, don't correct him. He read a book. He read a law book in the law library with the people at the desk. So don't sit there and correct him. Don't you dare do it.
communications or
Whoever told you that is wrong. You can file a request for order for mediation. You'll get for custody and visitation. You'll be referred to mediation and you will be given a court date. You don't need to file the declarations of disclosure. If you want to get a judgment of dissolution of marriage, you have to do that.
okay.
You can get temporary orders pending the trial on the divorce case. People go for years litigating property and stuff. They still get custody orders. The court isn't going to make you wait on vital things like child custody, child support, spousal support sometimes.
Yeah.
There's the availability of temporary orders pending the trial on all of those things. And if you are going to do that, file that request for order, then check the box for custody, visitation, and child support. Because the order that I'm making for child support today is going to be based on your having 1% with one child, 0 for 2. If that changes, we should change the support. Okay,
You
and
don't
so
know?
this says the income that they're using for you. Now, by the way, is there cash aid?
I
No,
don't receive any aid except for Medi-Cal for me and the children.
Yeah. Well, then it's only cash aid that matters. If there's Medi-Cal or even CalFresh food stamps, that's not something that they recover. Cash aid they do. It says your gross monthly income is $6,856 a month or any deductions.
For me. Well, I'm currently on unemployment right now. I had a job in November, all the way till November 14th. So I brought my W-2, but for
So this
year-
is the average of what you earned in wages. Now, this doesn't say anything about unemployment.
no. So I didn't divide it out in that way. I just did an average for all of 2025
Just on wages?
wages and the unemployment.
Well, but the unemployment is taxed differently.
I can move it.
You just need to give me the numbers.
It'll be 1950 for the unemployment. Well,
No, we're talking about average 12 months. So at best it's 1950 divided by 12.
and he said he started it in November.
You started receiving
Oh,
in November?
I think I started receiving in maybe, I want to say maybe mid-December or something like that, probably, or maybe it could have.
Did you get 2 checks in December?
Yeah.
It's on the bank statements that I sent in.
It'll be 162, just 1950 divided by 12. We just do for December. And then let me actually redo I thought he had 3 months of unemployment. So let me redo the average.
And then there's the side work that he does, being an HVAC technician.
Well, what's the full-time job that you have?
So gets back to my story, why I'm in my current position. In January, earlier this year, I got into a auto accident in a company truck. And that went to litigation, and I'm no longer able to actually drive a truck for any HVAC company currently. So that's the reason why my income's going to change significantly. I haven't been able to acquire another service technician job that would.
Well, wait, I'm sorry. The accident happened when?
Early this year. And so I was working for this company.
Early last year, you mean?
Oh, yeah. Sorry about that. It is 2020.
Okay.
So early
So
2000.
like January? Wait. Like January?
Yeah, January.
Okay, but you worked until November.
So what happened was, I did work till November, and it was with 3 different companies, and I did garner that income. I brought my W-2. I'm not trying to hide anything. It's just at this current time, I got fired.
But you had said that you can't work for any HVAC company because of the accident, but you did work for 10 months after the accident.
Yes, so I got rehired with the same company, but then later on in the year, November 14th, they fired me over that accident. So I was back temporarily, but because it went into litigation, they had a company policy that I couldn't stay on. So
Okay. So I assume that you're applying for work elsewhere?
I'm currently applying for work, trying to get. I'm going to set up benefits and everything.
Well, once you get that job.
Yeah, I'm not here to fight any judgment. I just want to do better, and I want to get the
But the
order.
judgment's going to be horrendous. If we use your average of 2025, what do you have for wages now?
It'll be 6,385.
Wait till you hear how the laws changed in California here, guys. It's pretty damn cool.
Okay. And 13 for self-employment. Right?
I have 162 for, wait, what was that? For self-employment, you said?
I'm sorry, unemployment.
Yeah, unemployment was 162.
Okay. And I've got self-employment for you. 1535 gross per month.
Self-employment?
Not you, her.
Oh,
What kind of work do you do?
Hairdresser.
And that's all you make as a hairdresser?
Yeah,
Wow.
haircuts are only $35 and hair color is between $150 and $200.
Do you rent a chair someplace?
Sir,
And how many days a week do you work?
5 days a week.
Well, that's less than minimum wage. I mean, it's like half a minimum wage.
With the economy, more people are going longer between haircuts and hair colorings and
I was going to make a joke. I said, not me.
Me neither.
Yeah, but that's like once a month. You know the deal. You shave every day, right?
Pretty much. Yeah.
But you don't need help doing that.
Not currently.
Well, okay. So actually, the higher and let me just look.
It'll make it go up.
It would? Yeah, okay. This is a new program that went into effect from the legislature last September. And so now the higher your income is, you would think the lower his support would be. Now, the higher your income is now, there are more bands of what percentage of your net income goes to child support than there used to be. And so the more your income goes up, the more the total net income that's available goes up and bumps it into a higher bracket. And so it makes his child support go up as your income goes up. So actually.
And that's a big deal. That's a humongous deal. If you've never been through child support, you're stuck if you have the children. Because, okay, let's say your bills are $5,000 a month, all right? And you bring in $3,000 a month, okay? And he has to pay $2,000 a month in child support, all right? That works. But let's say you want to earn some extra money to buy other things that don't include the bills. So you get a second job. Well, now, you bring in $4,000 a month instead of $3,000. It used to be, since you have more money, then you have to pay more support. He would have to pay less support. So you would get another job. You would bring in another $1,000 a month. But then they would drop his child support down to match what you got. So you get a second job, you earn this money, and you still only have $5,000 a month at the end of the day. So you were stuck at whatever income you were at. Once you got child support, you were stuck. The only way to change it would be like something drastic. Like you would have to get a job that would like double your pay or half your pay, like cut your pay in half. Because if you did anything else, like they would just plus it or minus it from what he's already given you and nothing. You couldn't get any extra money. You just couldn't. Now you can. Now if you get another job to make more money, their child support actually goes up with you. So you can now, parents who get child support are able to earn more money if they want to. It was so hard before. It's so hard. It's so, I mean, I know the people who have to pay the support don't like it, but the fact is children are expensive. And if the people who are paying support would have like full custody, they would be paying so much more than any child support amount this judge gives them. Like 5 times as much. You know, I mean, children are expensive.
It's more of a conceptual issue for me that you are making so little cutting hair 5 days a week, but for him, he's happy that you're only making $1,535 because that keeps his support lower. That being said, the lower is $2,667 a month. Now, with you on unemployment, that's more than you're getting from unemployment. All they're going to get is 25% of your unemployment. Now, you're not collecting anything yet, are you?
No.
I wouldn't think so. You don't have any other kids that you support, do you?
No.
Okay.
Bren, if I had feelings, I would be offended. I'm going to be offended anyway. I'm a hillbilly, guys. I'm a hillbilly. I need my moonshine. Where's my shine? Anthony got me my shine.
We have the same number?
2667?
Yep.
Yes.
Okay, so the start date is December 1st. And I mean, we have a lot of people that come through here that are in agriculture, that are in construction. And so this is the bad time of year. So making an average order like this is the bad time to be starting that. If it was in July, that'd be entirely different. That would be when everything was hot and heavy. But going forward for people like that, we just tell them, when you're doing well, you need to put money aside because your landlord isn't going to let you skate on rent, and you're still going to have to pay for utilities and buy food and all that stuff. So you got to save money when the going's good. I will add an arrears payment, although again, they're going to take 25% of your unemployment until you get back to work. I'll just make that $33. And then health and reporting orders, I'll make those mutual. If there are any medical expenses that aren't covered by insurance, you share those. When you get back to work, you need to look into getting child's or health insurance for the kids.
Yeah, I had health insurance for them all the way from from July to when I got fired, fortunately.
Okay. Yes. All right, that's your judgment. Good luck to you. Okay, bye.
So I thought that was so interesting. Like when I heard that, I couldn't believe it. I couldn't believe how freeing that is for the moms, dads that are on child support now. Oh man, please let this clip play. All right, we're going to go to Mertz.
Okay.
Right? It's Mertz, right? Is it Mertz? Judge Mertz? And I haven't played him for a while. I don't know why. He's a very good judge. But the last clip is the best clip. I did a bunch of these in a row. It's just not one case here. It's quite a few. And the last clip is the best.
Versus Brentley Dion. And if I could have counsel put your appearances on.
Good morning. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Lauren Madison for the defendant, Mr. Dion, who is to my right.
All right. We have this set for entry of a plea here today. Ms. Madison, is your client ready to proceed with that?
He is, Your Honor.
Okay. What are the terms of the plea agreement in this case?
Judge, under this plea agreement, Mr. Dion will plead guilty to 3 counts of failure to pay child support with a habitual second. And the state is offering a sentence agreement for a delay of 11 months. During that time, he must pay as ordered every month. If he's able to reduce his arrearages to $18,000, then he can be sentenced on 1 count of attempt failure to pay child support. If he's able to reduce his arrearages to $0, then he can plead guilty to 1 count of disorderly person. And the prosecutor agrees to dismiss count 4.
All right, Mr. Burke, is that a correct statement of the offer by the people?
That is correct, Your Honor. Yes, thank you.
Okay. Mr. Dion, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sure, I guess.
Well, I don't want you to guess. If you need more time to talk to her this morning, I'll give you an opportunity to do that.
I mean, I don't think that I think this is the only deal that they could come up with, so we can continue.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Dion, are you currently on any kind of probation or parole? All right. And you understand that the maximum possible penalty for each of these 3 counts as a second habitual offender would be up to 6 years. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to each of those counts here today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then you wouldn't be able to go any further with that appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to these charges because you are actually guilty?
Yes, Your Honor.
Okay. And there are 3. Ms. Madison, is the plea going to be to counts 1 through 3?
That's correct, Your Honor.
Okay. So, Mr. Dion, between July of 2019 and February of 2020, were you subject to an order here in Otsego County that required you to make child support payments?
Yes, sir.
And were you aware that you were subject to that order?
Yes, sir.
Did you fail to make payments in the amounts or at the times required under that order?
Yes, sir.
And did that also occur during a period between October of 2020 and January of 2021?
Yes, sir.
And then did that also occur between March of 2021 and January of 2023?
Yes, sir.
Okay. Had you previously been convicted of the felony of interfering with electronic communications here in the 46th Circuit back in 2016?
That should have come off my record because I completed the drug court program. It was 7411, I think they called it or something. And upon completion of the drug court program with Mr. Abe Cruz, it was supposed to be a high court misdemeanor, to my understanding.
All right, Ms. Madison?
Thank you, Your Honor. I was not aware of this until this particular moment. I don't know if the state is willing to amend the plea at this point. So there's not the habitual second.
In court last time, I said that there's no reason I should have an habitual felony because I mentioned me completing the drug court program.
Did that actually result in entry of a conviction to a lesser crime?
When I got sentenced, yes, that's what I signed the paper was for a lesser crime.
Okay. Mr. Burke?
Your Honor, my thought would be based on what the defendant's saying. It sounds like he maybe had a couple different charges. 7411 is for drug charges. This is it looks like the conviction is has nothing to do with a drug conviction or drug issue. So I mean, we could certainly look into it if the court's going to schedule what I refer to as a delayed sentence hearing, which is a hearing about 30 days out, that will result in the court placing the defendant on a delayed sentence per the plea agreement. Then we could certainly look into that. And then if there truly is a felony conviction for 2016, then the court can certainly take the factual basis for that at that time. If there's not, then the people would certainly move to dismiss that HAB second. I'm just not sure if the court is going to schedule a delayed sentence hearing. Some courts will place the defendant on delayed sentence right away after the plea. Some courts schedule those matters out 30 days because the court wants to see a PSI first. So I'm not quite sure how this court does it, Your Honor, but if there's a possibility of maybe scheduling a delayed sentence hearing and about 30 days out, we could certainly look into that at that time.
Okay. So I think that's a good suggestion. Do you have any objection to that?
No objection.
So the way we're going to handle this, because Mr. Dion, I mean, there's a very detailed legal framework for when past convictions can be used for purposes of habitual offender enhancements. In your case, it's either going to fit within those or it's not. It should be a fairly simple issue. So Ms. Madison, I guess your client's the one saying it shouldn't count. So I'm going to put the burden on you to look into that. If there's a statutory basis for to eliminate that habitual enhancement, then I don't think, I think the prosecutor would have to take it off.
Yeah.
So I'm going to place that on.
And we certainly would, Your Honor, of course. So.
Yeah, right. So we'll go ahead and schedule this. And Mr. Burke, I do generally set him for a delay sentence hearing later after a PSI, and I have a PSI prepared and everything. So we would have been doing that anyway. So it's not going to result in any kind of delay to the case. And then we'll address that issue. Mr. Dion, your attorney is going to look into that for you. And again, if it doesn't apply, then we'll take it off of there. But it may, because there are circumstances where you can have, a conviction not be considered for the public record, but it still can be used as an enhancement, and that may be it in this case. But again, your attorney will look into that for you. So we'll set this for a delay of sentence hearing. You're going to check in, Mr. Dion, with Mr. DeLeo here for probation before you leave today to set up a time for a pre-sentence interview, and then just make sure that you stay in touch with your attorney. Okay. Mr. Burke, anything? Yeah.
I was going to say, just for the record, I just want to make sure that the court is aware that people are satisfied with the plea as well as the factual basis. The people are satisfied with the court has complied with the court rules for taking the plea. So I just want to make sure the record is reflective of that.
Yeah, thank you. I got sidetracked there from my usual colloquy, so I appreciate that. Ms. Madison, are you satisfied with those matters as well?
Yes, Your Honor.
All right. So then, for the record, the court finds the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. Dion is guilty of each of these charges. The court will accept a guilty plea as to all three. And again, Mr. Dion, just make sure you stay in touch with your counsel. Okay.
Okay.
Thank you.
Thank you, Your Honor.
And Your Honor, is one last thing. I apologize. Do we have a date and time for the delayed sentence hearing, or is the court just going to schedule it and notice it out?
Yeah, we'll notice that out. It should be in about 30 days. And if you want to appear remotely for that, I don't have an objection to that.
That sounds great, Your Honor. Thank you. I'll let the Lansing office know. Thank you very much, Your Honor. Appreciate that.
All right. Thank you. That's all for that hearing.
And then, Your Honor, I have one other hearing scheduled with you this morning at 10:30 on the Joseph Trevor case. I just want to make sure that's still up. I think it's still going today.
Yes, that is on the docket still.
Okay. So do you want me to? I can certainly log off, Your Honor, and then log back on at 10:30. That's not a problem.
Okay. Very good. Thank you.
Absolutely, Your Honor. Thank you so much. See you then.
Ms. Steele, if you'd like to come forward to the podium there, please. We'll call People versus Leah Steele, file number 256922. The record should reflect Ms. Steele's present here in the courtroom today. If I could have file number.
Thank you, Your Honor. For the record, my call on behalf of the people. And good morning, Your Honor. Attorney Trooper Dobies, P number 87722 on behalf of Ms. Steele. Steele, could you state your full name for the record?
Leah Marie Steele.
Thank you. This is the date and time set for sentencing in this matter. Mr. Dobies, I did receive your sentencing memorandum. I had a chance to review that prior to the hearing today. Ms. Steele, have you had an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, Your Honor.
Mr. Dobies, are there any additions, deletions, or corrections to the factual information within the report?
Yes, Your Honor, there were just a couple. I'm going to start on CFJ 145, page 2 of CFJ 145.
Okay.
On the, what I'll call the sentence that's a recommendation that discusses what the sentencing recommendation is. I believe there's an extra period in the middle of that sentence at the end of the first line. At least it looked like it was like that on my copy. So I think that was just a typographical error.
Where is that?
Where it actually talks about, one moment, Your Honor. So it's going to be, it is respectfully recommended that the defendant be sentenced to incarceration at Zio County Jail with credit for 11 days served. It looks like on my copy, right after the word served, there might be a period there.
Yep, I see where you're talking. Okay, we'll make that correction.
And then CFJ 284, page 4, where it discusses Ms. Steele's family, her half-brother, that should be Steele on the last name. I believe that is just a typographical error as well.
Stell, yeah, okay, we'll make that correction.
And then just one addition on CFJ 284, page 6, under the substance abuse treatment section. Ms. Steele does have a bed waiting and ready for her as of tomorrow at the Sacred Heart Clearview Women's Rehabilitation Facility in Richmond, Michigan. So I would concede that she has not started that yet, but I suppose it would be appropriate to maybe list tomorrow as the start date because she does have a bed ready to go. And that would be an inpatient treatment.
Mr. Rolla, do you have any objection to adding that information in?
No, Judge.
Okay, we'll add that in then under that section. Any other?
That was it for me, Your Honor.
All right. And Mr. Dobies, are there any challenges to the scoring of the guidelines?
There are not on either count, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, Judge.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yes, thank you. As to the request for 7411 in this particular matter, there is no doubt in people's mind that the co-defendant, Mr. Pearl, who, by the way, was the gentleman who logged in and told the court that, oops, I'm sorry, I dialed the wrong number.
Okay.
For the court's information. I noticed the court officer also recognized that, and he can confirm that for the record should the court need it. But there's no question that Mr. Pearl, who's also the father of the party's child, bio-father, I use that term as bio-father because I don't know that he needs the full definition of father, used Ms. Steele effectively as a drug mule to shield himself. I would point out to the court that even though that's the case, as the court's well aware that this defendant already received the benefit of having counts 1 and 2, which were 20-year Class B felonies, and counts 5 and 6 also dismissed. That would have resulted in a recommended mandatory prison sentence. Further, this is a situation we were talking about over 12 grams of methamphetamine, actually almost 50 grams if you add in the 30 additional grams that the third party, Mr. Larry Monk, had. If the court recalls at the car wash, that's where the 30 grams were stashed. If the court remembers in this particular case. Also, this case involved Xanax, which is alprazolam, hydrocodone, as well as clonazepam. As to additional reasons why this should not, and quite frankly, I don't believe cannot go as a 7411, it would create sentencing problems in regards to reporting it because the offense for it involves a weapons offense, and that has to remain a public record up until or unless at a later date and time the defendant was in a position to appropriately bring a motion to set aside a prior conviction. That's different from 7411, as the court's well aware. So I believe there are both legal, factual, and practical reasons why 7411 should not be awarded in this particular case. As to the rest of the recommendation, I think it's appropriate, with, of course, the fact that the metallic buckles are confiscated and condemned pursuant to MCL 75239. Thank you, Judge.
Thank you. Mr. Dobies, anything on behalf of your client today? And again, I did read through the sentencing memorandum, so I'm kind of aware of your position on the case generally. And
That's how I used to watch almost all my pirated movies on Prism. Back in the day, you put this little chip in the back of your box to get Prism, and that's how you were able to watch all the movies.
The 7411 request.
Thank you, Your Honor. I'm going to strive to not repeat too much of myself in the sentencing memorandum with that understanding. Ms. Steele comes before the court, as I believe Mr. Rolla outlined, in a pretty precarious position. I think that's fair to say. And getting involved with an individual that's very well known to this community. Obviously, Ms. Steele did not know that at the time. She's come to be aware of that. But I think that this court should know that Ms. Steele has taken her sobriety very seriously. As the PSI indicates, Ms. Steele has not been involved with methamphetamine for that long. I say that not to minimize the fact that the scourge that methamphetamine is on this community and this state, but I say that to just observe to the court that Ms. Steele has not, she's not too far gone in terms of her ability to be rehabilitated and recover from this substance use addiction. And as I mentioned before allocution, Ms. Steele has now taken it upon herself to engage in inpatient services. During the pendency of this case, she has taken advantage of outpatient services. Quite frankly, she believes she needs a little bit more structure than that in order to overcome this substance use disorder. So that's why she's taken it upon herself to, again, this inpatient treatment. I understand how this case started out. It started out as a delivery of methamphetamine case. So I'm certainly not blind to that. And in regards to the sentencing recommendation, the probation and parole department has recommended a term of incarceration consistent with the guidelines, but a jail-only recommendation. I certainly understand the punishment factor that this court has to take into consideration. I would just ask that if Your Honor is inclined to give any jail, I would be, first of all, asking for no further jail as I outlined in my sentencing memorandum. But if Your Honor is inclined to impose additional jail beyond the 11 days that Ms. Steele has served, I would ask that that be held in abeyance pending this inpatient treatment that Ms. Steele has verified to me that she has a bed for. And if she successfully completes that inpatient treatment, I would ask that she be, to the extent that the court is willing to do so, give her day-for-day jail credit as long as she successfully completes that inpatient program.
We don't see this often, and I wonder how it's going to go. And there's no way for us to know. We'll never know, but they caught her early. She's only been using for a short amount of time. She's addicted, but only for a short amount of time. So they all really think this one can be saved. They can put her into treatment right away, and she'll be okay. I mean, who knows? We don't see people who are right at the beginning where you can still, I guess, I don't know.
And I will leave it at that, Your Honor, as to not repeat myself too much. Thank you.
All right, thank you. Ms. Steele, anything you wanted to say today? Okay. As you've heard, I did read through all the reports that were filed in this case, so I'm familiar with you, generally your background based on the information in that report, your past history, and what happened in this case. Obviously, Mr. Dobie's memorandum went into a little bit more detail and provided the court with some additional information just about your general circumstances. And there's a couple aspects of this case that I think stand out. Number one,
she paused it at the wrong time. Do you prefer Holly, Naomi, or Holly Naomi? What do you prefer?
It appears that you were involved pretty heavily in this delivery circumstance, and probably others as well, due to your association with these other individuals. And if you don't know it already, you're going to find that the more that you associate with people who are involved in this, the more you're going to get dragged into it yourself. Whether you start out that way or not, you're going to end up involved in it. And that's why you're here today. And I generally look at cases involving delivery with a much more critical eye than I do just use or possession cases, because not only are you using, but you're bringing it here and making it available for other people to use, and that presents a danger to our community. And those things are all what I would consider aggravating factors, or make a case for you doing some jail time much stronger than it would otherwise be. I also think there's some mitigating factors here. Number one, your lack of any real past criminal history, I think is significant. I think that gives the court some reason to believe that it should look at rehabilitation first, rather than punishment. And while it does appear to me, based on the report, that you've had some slip-ups while you've been on bond, I also am seeing evidence of some sincere efforts on your part to get help and get treatment. And one thing that I tell people all the time is, it's one thing for the court to order somebody to do it, or for somebody to do it because they want to keep themselves, make it look better. If you're seeking treatment on your own because you want to get better, that's when it's really going to be effective. And so I hope that's the reason why you sought this. But either way, again, it gives me some reason to believe that there's potential for rehabilitation here. So when I look at all of those factors and trying to come up with a sentence that I think is fair and reasonable and addresses your conduct, but also the rehabilitation aspect, in my view, and in particular, given your lack of any past history, that probation is appropriate for a period of time to provide for supervision and oversight. I think jail time held in abeyance, so that you understand that if you don't comply with probation and treatment, which I'm going to discuss here in a second, that there's a significant jail sentence waiting for you on the other side of that. And if I give you the opportunity for rehabilitation up front and you don't take that, or you don't follow through with it, if you're back here, you're not going to have any argument really that's going to convince me that you shouldn't just go to jail, because you will have had that opportunity and you will have rejected that opportunity. So I'm going to place you on probation for a period of 24 months. That's definitely not the easy way out. That means you've got 2 years that you're going to have to toe the line. I'm going to impose 12 months in the Otsego County Jail with credit for 11 days served. I will allow you to be released to treatment immediately. And if you successfully complete that treatment, then the court will give you day-for-day credit for the time that you're in the inpatient treatment at Sacred Heart, I think. Is that what you said?
Yes, Your Honor.
And then if you successfully complete that program and you're released, then I'll continue to hold the remaining jail time in abeyance. Now, you'll still be on probation after that. And if you violate your probation, I can impose that jail time. So it doesn't just go away by successfully completing your treatment. But hopefully that treatment program is going to give you the tools you need to stay clear of this during the time you're on probation. If you don't successfully complete the probation, or you leave, if you don't successfully complete the treatment, or you leave before the program is finished, you're going to have to report to jail. If you don't report to jail, we'll issue a bench warrant and you'll be arrested and brought to jail. And I want to confirm that you do have a bed available. So you're going to be taken into custody here today. Mr. Dobies, you can work with the jail as long as they have confirmation from Sacred Heart that she's got a bed available, then she can be released tomorrow to go to the treatment. In terms of the probationary provisions, the court is going to adopt all standard terms and conditions of probation. You need anything more than that, Mr. DeLeo? Okay. No. And again, that'd be for a period of 24 months. The court is going to order a crime victims assessment of $130, court costs of $325, a DNA testing fee of $60, and a $68 state cost, along with a supervision fee of $30 per month while you're on probation. And Mr. Dobies, if you can have Ms. Steele acknowledge receipt for appellate rights there.
Which condemning the telecom, Your Honor?
Yes, for the record, the court will order that those be seized.
And Your Honor, just for the record, I'm going to place on the record that my client is right now dating and initialing the appellate right stuff.
And if I didn't say it, this deal has 11 days credit.
That's correct, yes.
We don't get to see the gallery in this courtroom.
And Mr. Dobie, just so you're aware, I've got this worksheet that I'm providing to the jail that indicates that Ms. Steele can be immediately released to treatment upon confirmation of bed at Sacred Heart. So
thank you, Ron.
That to you. And good luck to you going forward.
Thank you so much.
Thank you, Ron.
Yes.
Judge, on that judgment, do you want me to put per confirmation before release?
I love peanuts.
Okay, okay.
Mr. Brown, did you have Miss Haley?
Mr. Haley?
Or Mr. Haley, yeah, sorry.
Lodge downstairs, Your Honor.
Oh, okay, yeah. Oh.
And Judge, that was not with 7411, correct?
What's that?
That was not with 74. Okay, thank you.
Are both of your clients lodged, Mr. Brown?
Who's the other one?
Ms. Hammond?
We could call that case.
We'll call People versus Kimberly Hammond. This is file number 256869. If I could have counsel.
For the record, Your Honor, my call, yeah. There's Brown on behalf of Ms. Young.
This was set for hearing at 9:45. It's now 9:55. Have you had contact with Ms. Hammond today?
I have not, Your Honor. I did send an email to your assistant as well as the prosecutor that the phone has been disconnected. I have not had any response to my emails. I did reach out to Jessica Van Wolfen to see if she has been reporting. We do have the same phone number, and Ms. Van Wolfen has not had contact with her since October. That is when we had, I believe, a motion hearing.
Okay. All right. We currently have that set for trial on January 30th. Mr. Roll, is there anything that you wanted to add?
Judge, I would confirm for the record, our office did receive the communication from defense counsel regarding both his client not being in communication with him and the phone number being
I would be a messy lawyer as well, but that's why I would be good.
disconnected, as well as from Ms. Van Wolfen. She confirmed in our office that apparently Ms. Hammond has not been reporting as required as a condition of bond or pre-trial, at least depending on what it wants to say. It wants the same thing. Since at least October, I would request, since she has not appeared for the hearing, and I would note the time is now 9:58 for Ms. Hammond's 9:45 hearing, that the court do two things. One, call off the jury so that we do not have live personnel showing up like we had last month for another matter.
Like we had last month for another matter. His attorney was just burned a couple days ago. Jury trial is set for tomorrow. And no one has seen her since October.
Unnecessarily, along with 60 some odd potential jurors, and also issue a bench warrant for Ms. Hammond's arrest so that she can be located, found, and brought back before the court, and then held without bond until the trial.
Okay, so based on Ms. Hammond's failure to appear today, and with the trial date coming up here in 10 days, the court will request that the people prepare a bench warrant for Ms. Hammond's arrest. We do have another trial stack with that one, the Price case. Right, so we'll adjourn this trial, and assuming there isn't a plea today, we'll move forward with the Price trial on the 30th. If Ms. Hammond appears on January 30th, then the court will just take her into custody at that time and we'll reset it. Otherwise, we'll proceed further with this case once Ms. Hammond is arrested and brought before the court. Mr. Brown, anything further for the record on that file?
No, Your Honor, thank you.
Mr. Rowland?
No, Your Honor, thank you.
Sir, is your name Michael Haley?
Asked if you were Haley.
Yes, sir.
Okay. We'll go on the record in People versus Haley. This is file number 256876. The record should reflect Mr. Haley's present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record, Michael People, Larry Brown on behalf of Mr. Haley.
All right, Mr. Brown, this is set for a motion to withdraw.
It is.
Are you appointed in this case?
I was appointed in this case. This is at my client's request. He did submit a request to Mr. Slough as well, which I don't know if the court received that, but I was notified on the 16th, which I believe was Friday, that request has been denied. Mr. Haley has advised me that he may be looking, I guess he could expound on this, trying to retain Mr. Jeffrey Weiger as his private counsel. At this point, in my meetings with him, we have gone over this case. We've reviewed video footage, different things like that. I'm a little, unless he definitely just wants to retain private counsel, confused, because we seem to agree on pretty much everything as far as the facts of the case, the strategy, the trial going forward. I've explained to him some of my strategies.
Then why is he firing you, sir? Why is he trying to fire you 10 days before trial? What did you do to him? Look, it's obviously not his fault. Look at him. Obviously, he knows about his case way more than this lawyer thinks he knows about this case. So the lawyer should just be fired. If I was his lawyer, I would be like, Judge, fire me.
Are you having trouble hearing Mr. Haley?
Yes, Your Honor. He's turning up the volume.
Okay. All right, go ahead, Mr. Brown. Maybe if you can just speak up a little bit too, because the microphone's over here.
I can hear fine now.
Okay.
There are some things that he wanted me to do, which I did go over those with him. I don't want to get into our conversations, but he seemed to understand certain reasons why I might not want to do those, that it might actually hinder the case. There was some witnesses that he...
You know what, Letus? I'll take 1,000 there or 100 there. $10.60 air. I'm in.
He wanted me to contact that he thought would be very helpful. Two of them I am trying to track down, but all I have is a name. I don't have an address or a phone number. I did contact one and did explain to Mr. Haley I would not call that person. I believe it would be extremely detrimental to his case.
So I'm at a little bit of a loss. I did file the motion to withdraw because that is what he wanted me to do, and he is trying to get new counsel. But at least the way I see the case.
If I find 100 air, don't worry, I'm bringing y'all with me. We're all going to share in that $100.
And in my conversations with him, I think we both agree on the way it's headed forward. And I was going to go down and go over some things that we are going to need to do if this trial proceeds on Monday. But if he can retain new counsel, I would definitely not want to infringe upon his right to do that.
All right, Mr. Haley, we have your case set for trial starting next Monday. I'm not going to appoint a new counsel for you. We've went through that process. I don't think there's grounds based on what Mr. Brown has stated today. So your only other option would be to hire a different lawyer for yourself. If you did that, I'm sure that that lawyer would want to have some time to prepare for your case. And that means that we'd have to adjourn that trial, and you are going to spend more time sitting in jail waiting for a trial date. So how do you want to proceed with your case?
Well, as Mr. Brown said, we have not had a good working relationship. He makes promises he doesn't follow through with.
That's absolutely just not what he said. None of that is what, as Mr. Brown said, I was involved in the Kennedy shooting. That's not what he said.
I made a request quite some time ago to change the attorney to avoid this eventuality.
Yeah, and I understand that, and that request was addressed, and it was determined that whatever, differences you have, they aren't significant enough that it would warrant having a new counsel appointed.
I was completely unaware of that, Your Honor. I thought I had no idea that it had been denied.
Well, that's where we're at.
Understood.
So again, I mean, your options at this point are to proceed with trial with Mr. Brown next Monday, or you can try to hire your own counsel. And again, I'm sure that any attorney coming into the case now is not going to want to have to try and go forward with the trial, especially given the nature of the charges here, without any time to prepare.
Understood, Your Honor, but I do not have funds to hire another attorney.
Okay, so I'm going to proceed with going forward with the trial next Monday then. And I encourage you to communicate as much as you can with Mr. Brown between now and then, and address whatever differences that the two of you have. But we need to go forward with the trial.
Understood, Your Honor.
Okay.
All right, Mr. Brown, anything further?
No, Your Honor, and I will be contacting his son, and if I can't get anywhere there, I am going to ensure that he has clothes for trial.
Okay.
I don't think he brought any.
Stop.
Mr. Haley,
Pause. He's going to make sure he has clothes for trial, guys. That's important. Out of everything we saw tonight, I just want you to know this man is going to have clothing when he goes to trial. Don't think about the opposite. Try not to picture the opposite in your head right now. Don't think about that.
Clothes into the jail, did you?
Only what I had on.
Okay.
And
okay,
I asked, and those aren't even here for some reason.
Okay, so Mr. Brown, again, I'll just ask that you take whatever steps necessary to make sure that you're ready to proceed with Mr. Haley's case next Monday, and that Mr. Haley has street clothes. I believe we've already had jury instructions submitted.
We did them a while.
So Mr. Brown, if you could just submit review the prosecutor's instructions, if there are any that are different or ones that you need to add, if you can just submit those.
Yes, Your Honor.
To the court. I believe, Mr. Rolla, how many are you still anticipating? We had set for 4 days, is that correct?
Yeah, Judge, and with the number of witnesses, the number of lab personnel, I think it's going to take all of 4 days.
Okay. All right.
4 days, guys, 4 days, but don't worry, he's gonna have clothes on for those 4 days.
Mr. Roll, anything further for the record today?
Not in this case, thank you, Your Honor.
All right, Mr. Haley, do you have any other questions today?
No, Your Honor.
Okay. All right, thank you. That's all for this hearing. The court is going to disconnect at this time.
Granny, that would be awesome. Who's gonna convict Santa Claus? Who's gonna put Santa Claus in jail? Of course, get him a Santa suit. Of course. It's not fair, because when women are on trial, they get to dress, as cute as possible to make them look innocent and pure or whatever. Men get suits, well, a lot of evil happens in suits. You know what I mean? They don't have any cute, innocent outfits. Men don't get that. They just don't. Unless it's frickin' Santa Claus. He's the only one who can pull it off. Get him a Santa suit. Oh, we're too early for OJ. I'm going to start OJ early, because we're at the end. Guys, thank you so much for coming out with me today. I don't know what's going on with technology. I mean, I don't know. I don't know why the video wouldn't play. I don't know why my power went out last night. I don't know why. So I'm sorry, but we made it through. Thanks for coming out. I think I got a really good one for tomorrow. I got a judge, I think, that's really getting a domestic violence guy. So we'll see if that's any good, and I will have that for tomorrow. But for today, behave, be nice, and I'll see you again real soon. I'm going to set up OJ. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself.
Can anybody hear me right now?
Her cases
Can anybody hear me?
are new with a
I wasn't
twist
muted.
or
I need to know if my mic works.